Hello friends, in this lecture on industrial accidents and labor law in India, we will be discussing the increasing number of cases of industrial accidents in India, how the blatant violation of labor law in India is leading to these industrial accidents, and how there has been a progressive erosion of workers' rights both before and after these industrial accidents. We will also be discussing the four labor codes in India, and we will be discussing the loopholes in these codes. After that, we will be discussing the suggested improvements in these labor codes. Then we will discuss the new draft labor policy of the Government of India. And finally, we will be doing a practice question on this lecture. The picture that you see here, that of the industrial accident that occurred in June 2025 in the Thagachi Industries in the Sangareddy district of Telangana. Now, this is a list of some of the major industrial accidents that have occurred in India. Although the list is very long, but we have taken a few examples. First infamous incident is that of the Bhopal gas tragedy in 1984. In this incident, there was the leakage of methyl isocyanate gas, which led to a death of large number of workers and also long-term adverse impact on the health of a large number of other people. Now, in the Bhopal gas tragedy, there is evidence to show that the maintenance norms were not followed. There was lack of compliance with the provisions of the Factory Act. The flare tower was not adequately maintained. Now the flare tower is a tower which the toxic gases they are converted into harmless components. And these toxic gases are burnt so that they are not released into the atmosphere. Also the scrubber, it was not properly maintained. Now the scrubber helps in absorbing or adsorbing the toxic gases. So the maintenance norms were not followed. Also, in order to circumvent the provisions of the Factories Act, bribes had been paid to officials by the factory management. Then about the incident that occurred on 3rd of April 2024. There was a chemical explosion in the SB Organics factory in the Sangareddy district of Telangana. 6 people were killed and 19 were injured. Now, after this incident, there was a report which came out, and the report said that the management as well as the regulatory authorities, both were not aware of the health and safety norms. And this report, it was not signed by the officials, and this report, it was just shelved, and compliance with this report was not carried out. This shows how the governments, they are not learning from their mistakes. Then in the same Sangareddy district, on June 30th, 2025, in the Sigachi Industries in Telangana, there was another industrial accident and a chemical reactor burst. And in this incident, more than 40 workers were killed. Then on 1st of July 2025, there was an explosion at the Gokulesh fireworks in Shivkasi, Tamil Nadu, and 8 workers were killed. On September 30, 2025, again a 10-meter high coal handling plant collapsed in Chennai's Ennore thermal power station, and 9 workers died. And 3 days back, in October 2025, there was a blast at a firecracker unit in a village in the Konaseema district in Andhra Pradesh, and 8 workers were killed. The norms of the Petroleum and Explosive Safety Organization, the norms that have been mandated by this organization, they were not followed, and safety norms were not followed, because of which the blast at the firecracker unit occurred. Also, this firecracker unit was located near the Godavari river, where there are a lot of oil and gas deposits. Also, there are a lot of pipelines that are running nearby, and so if the fire spreads to these, then even a disaster of greater impact can take place. Also, the norms that had been prescribed by Petroleum and Explosive Safety Organization, multiple layers of checks, they had not been followed. Now, the British Safety Council, it estimates that 1 in 4 fatal workplace accidents worldwide occur in India. So this is very concerning. Also, there is underreporting of workplace injuries and deaths, especially among the contract and informal workers, because their employment is neither registered nor protected by law. Now, what happened in the Telangana explosion? It was found that the reactor was operating at twice the permissible temperature. So, the reactor was operating at twice the permissible temperature. Now, it was the equipment, the material that was being manufactured in this Telangana factory, it was MCC. Now this MCC stands for microcrystalline cellulose, and this material it is commonly used by the pharmaceutical industry binder, as a binder, filler, lubricant, and disintegrant. So it is used in the pharma industry. Now what happened here was that initially there was an explosion in the spray dryer, and after that there was a secondary explosion which was a dust explosion, and this secondary explosion it triggered the collapse of the building. Now the reactor was operating at twice the permissible temperature, the sensors were not working, no alarms went off, no safety officer intervened, so the safety norms they were not followed. Then the machinery was also outdated. The workers had also complained to the management that there was outdated machinery, but the management was solely concerned with profit making and cutting costs, did not pay heed to them. So the maintenance was ignored and worker complaints were dismissed. Then the required on-site ambulance it was missing. So ambulance was also missing. And because the ambulance was missing, the injured they were taken to the hospital in a damaged company bus. And what is very saddening is that they did not even know how many workers were working in that factory. So even after 1 week, the authorities they could not determine how many were missing. Why? Because there were unregistered workers, workers were not registered, and there were no entry and exit records, so no records were maintained, no records of the workers were maintained. And majority of workers here, they were not permanent workers. So they were either contract workers or they were fixed term workers. Records were not maintained, so authorities did not even know how many workers were working there. And this was a highly hazardous plant, and safety norms were not followed. Now, inspection had been carried out in December 2024 also, and this inspection report has been leaked, and this was before the accident took place. And this inspection report had pointed out several lapses at Sigachi. What were these lapses? One was inadequate fire equipment. Proper fire exits were not there. There was absence of insulation near the electric panel board. There was absence of rubber matting or insulation near the electric panel board. Now the electric wiring was loose and temporary. Also, there was lack of automatic fire extinguishing appliances, so fire extinguishers were not there. Then absence of an inert gas suppression system to manage electrical emergencies. So there was no proper provision for management of electrical emergency. So in case a fire was triggered due to electrical failure, due to uh, the electrical failure, then there was absence of inert gas suppression system. Now this report, which was prepared in December 2024, also mentioned that workers they were not provided with personal protective equipment. So the management was not concerned with the safety of the workers. There was no proper following of safety norms. Also, there was lack of proper training of the workers. Workers were not trained properly. They were not aware of what they were handling. Some workers believed that they were not even handling chemicals, so they did not even know what they were handling. Such was the extent of ignorance of the workers. Also, the PCB inspection, that is the Pollution Control Board inspections, they were lax. This can be proved by the empty environmental display board. So there is an environmental display board which is supposed to contain information about the effluents, the hazardous waste that is generated in the factory and other details. So there was no environmental safety board in the Sigachi industries. Now another incident that occurred now this Sigachi incident, it occurred in Tamil Nadu in the in Telangana. In the northwestern portion of Telangana, there is the Sangareddy district, and here where the incident occurred. And there was another incident that occurred in Ennore, that is near Chennai. And here what happened was that the coal handling structure fell. And the reasons cited were due to faulty design, due to poor quality scaffolding. Scaffolding means the supporting structures. You can see in the picture here, this is the supporting structures which fell because they were of poor quality. Safety norms were not being followed, and inadequate anchoring. Now, in recent years, similar accidents, they have spotlighted the issue of watered down regulatory checks. So regulatory checks are not proper, diluting of regulatory norms and negligence. And successive governments, they are not course correcting themselves. So if one incident occurs, then the government is not taking the report seriously. As we have seen that in the SB Organics chemical factory in the same district, Sangareddy district, there was an incident in 2024. And the report was prepared, and the report said that the management and the regulatory authorities, they were not aware of the health and safety procedures that were to be followed. And this report was not signed by the officials, and it was not paid heed to. And what happened as a result? As a result, another disaster occurred. Another disaster occurred in June 2025 in the same district. So this shows how negligent we are. Also, except in cases of complaints and accidents, inspections and verifications from factories department have been eliminated as long as industries submit self-certification or third-party verification. So the norms have been diluted, and as long as the industries are submitting self-certification or third-party verification, they are not being subjected to inspection by the factories department, by the inspectors of the factories department in the government. This shows dilution of the labor norms, dilution of the fact in the provisions of the provisions that are governing the industrial safety. So only self-certification and third-party verification is now sufficient, and proper inspections by the inspectors of the government, they are not being carried out. So those inspections by the government, by the factories department, they are being carried out only in cases of complaints or accidents. Otherwise, in all other cases, there are no inspections by the government, by the factories department, and self-certification or third-party verification, self-certification by the management of the factory or third-party verification, that is adequate. So in Telangana also the government had not carried out proper inspections, and self-certification was adequate, and this led to ignoring of the safety norms by a large number of industries. Now the International Labour Organization, it confirms that why do the industrial disasters occur? They occur because the management is cutting corners. Management is not investing in safety. It is under investing in safety. Why? Because management only wants to make profits. It wants to reduce cost. And when accidents occur, the employers, they often blame human error. They put the blame on the workers. But what are the real causes? The real causes, they lie in the practices of the employers. And there are long working hours for the workers. Workers are not being provided adequate rest. There is a lot of excessive work pressure, and wages are very low. Since the wages are very low, workers are forced to take double shifts in order to make ends meet. And workers are not properly informed about the safety practices. They don't even know what they are handling. As we have seen in the Telangana factory blast case, workers did not even know what chemicals that they were handling. They were not provided with adequate training. Now about the labor laws in India. During the pre-independence time, during the British time, there was the Factories Act of 1881. Then after independence came the Factories Act of 1948, which is now proposed to be subsumed under the Occupational Safety, Health and Working Conditions Code of 2020. Now this Factories Act of 1948, it governs everything from factory licensing and machinery maintenance to working hours, rest breaks, canteens and crèches based on the principle that decent working conditions and safety go hand in hand. Now this Factory Act, it was amended twice in 1976 and 1987. So in 1987, it was after the Bhopal gas tragedy. As we have seen in the Bhopal gas incident, there is evidence to show that the compliance with the provisions of the Factory Act was not done. Also, bribes were paid to the officials in order to circumvent the provisions of the Factory Act. Maintenance was not carried out for the flare tower as well as for the scrubber. So there was an attempt to bypass the provisions of the Factory Act, and this led to the disaster. Then there are certain laws that are governing the compensation to the workers, and these laws include the Workmen Compensation Act 1923 and Employee State Insurance Act 1948. They recognize compensation for the loss of earnings, including lifetime income. However, in practice, such compensation remains meager. So this compensation is very small. In case of industrial disasters, these laws they do not hold the employer criminally accountable. So criminal accountability is not placed on the employer. So employers often escape punishment. Also, if there is a lot of media attention on the industrial accident, then the governments, they get away with giving ex gratia payments from public funds. Employers are absolved of the responsibility. Now, what is the situation now? Since 1990s, labor protections have been systematically dismantled. In the name of ease of doing business, we are diluting the labor laws. Now, employers, they demand flexibility. Employers want flexibility, including the freedom to hire, fire, and extract workers without oversight. So, employers, they are happy if there is minimum oversight or no oversight, and they want the freedom to hire and fire workers. And the governments, they are obliging these employers. They are weakening the inspection regime, they are diluting the laws, and they are branding the safety regulations as obstacles to business. Now, the government's ease of doing business campaign has pushed the other states also to follow the direction of diluting the labor laws. Now, in 2015, the Maharashtra government, it allowed employers to self-certify compliance with labor laws. So it allowed employers to self-certify compliance with labor laws in the name of ease of doing business. Also, the Telangana government had also allowed the employers to self-certify compliance with labor laws. So the government said that the routine inspections by the labor inspectors of the factories department need not be carried out, and only in case of accidents those inspections will be carried out, and otherwise self-certification or verification by third parties, that will suffice. Now, the Occupational Safety, Health and Working Conditions Code of 2020, once enforced, this code has not been implemented fully, but once enforced, it will move health and safety from being a statutory right to executive discretion. Now, ideally, it is the legislature which should prescribe health and safety norms to be followed by industrial establishments, because if there is legislative oversight, then it is more likely that the laws are going to be fair. But now this occupational safety code, it gives wide discretion to the executive. It allows the executive to prescribe the conditions, the safety norms that are to be followed by industrial establishments. It also allows the executive to exempt certain industries from application of the code for a certain period. It allows the government to exempt certain industries in public interest. It says that if factories are creating employment and economic opportunities, the government may exempt them from application of the labor codes. This gives wide discretion to the government, and this is erosion of workers' rights. Now, states have also increased their working hours. States have increased the working hours of workers, and this practice started during the COVID pandemic. And this has dealt a major blow to safety. In 2023, Karnataka made this permanent. Karnataka increased the daily limits on working hours, and the state government reduced the rest periods. This is a cause of concern. Also, we have seen that businesses, they want to extract maximum from the labor with minimum responsibility. Now we will study about the four labor codes. That is the Code on Wages 2019, which regulates the wages of the workers, then the Industrial Relations Code, then the Code on Social Security, and the Code on Occupational Safety, Health and Working Conditions. First, we come to the Code of Wages. Code on Wages. This Code on Wages, it subsumes four laws, and these laws include the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act of 1965, and the Equal Remuneration Act of 1976. Now, the Code on Wages says that it covers all establishments and all employees in the organized as well as the unorganized sectors, covering all establishments as well as all employees, the organized as well as unorganized sector. Now, what is an establishment? So, the code says that an establishment is a place where any business, trade, or occupation carried out with 10 or more workers. So, this is the definition of establishment given in the code. It says is a place where any business, trade, or occupation being carried out with 10 or more workers. Now, this definition of establishment has been provided for in the Code on Wages, in the Code on Social Security, but it has not been provided for in the Occupational Safety Code. Now, the Code on Wages, it further says, also in the Code on Industrial Relations, it has been provided. So, definition of establishment has been provided in the Code of Wages, Code on Wages, Social Security and Industrial Relation. It has not been provided in the Occupational Safety Code. Now, the Code on Wages, it says that there should be uniform applicability of provision of timely payment of wages, minimum wages to all, and bonus payment all employments where any industry, business, trade or manufacturing is carried out. Now, one important provision of this code is the concept of floor wage. Now, the code says it prescribes a minimum floor wage that is to be paid to workers, and this floor wage will be decided by the center. Now, it will be decided based on the living standard, and living standard will vary according to the geographical area. So, accordingly, the central government will decide the floor wages for different geographical areas. Also, in determining the floor wage, the government will consider the difficulty level of work, and the skill required for doing that work. So these factors will also be considered. Now, what if a state paying more is paying less than the floor wages? Then it has to increase the payment to that of the floor wage. Now, if the state is paying more than the floor wage, it is greater than the floor wage, then in that case, the state cannot reduce the wages that it is paying. Now, suppose the floor wage is rupees 500 and the state is paying rupees 1000. Now, the state is not allowed to reduce the amount that it is paying. Now, the minimum wage should be above the floor wage. If it is higher, if any state is paying higher, then it cannot reduce. And the next important provision of the code is that there should be no gender discrimination in wages and recruitment of work of similar nature. So, in case of work of similar nature, there will be no gender discrimination. Now, what is a work of similar nature? It includes a work which is similar in terms of the skill required, the effort required, the experience and the responsibility required. Now, this code on wages also defines wages. What are wages? So, wages include salary, allowance, or any other monetary component. But wages do not include bonus or traveling allowance. So wages will not include bonus or traveling allowance, will include salary, allowance or any other monetary component. Then this on wages talks about working hours. The working hours, they will be fixed by central government or state government. At present, the working hours have been fixed at 8 hours. Also, it says that in case the worker is working overtime, then the compensation needs to be paid, and the compensation that is paid needs to be twice the standard wages. So if the worker is receiving wages of rupees 500 per day, then if that worker is working overtime, that worker will be given 1000 rupees. Now the wage period. The wage period can be fixed by the employer. The wage period can be daily or weekly or fortnightly, that is in 2 weeks, or monthly. Then the code on wages says that advisory board, they will be constituted by the government, and these advisory boards, what will they do? They will advise the government on the minimum wage fixing. So how much minimum wage should be fixed? Advisory board will advise regarding how much minimum wage should be fixed, and also regarding how the employment opportunities for women, they can be increased. Then the code on wages talks about penalties for offences by the employer. So if the employer is committing offences, the code on wages prescribes penalties. For example, if the employer is paying less than the minimum wage, then the penalty is 3 months jail plus 1 lakh rupees fine. Now we come to the next code. The next code is the code on industrial relations. This code on industrial relations, it is subsuming 3 laws. Now what are these 3 laws? These are the Trade Union Act of 1926, the Industrial Employment Standing Orders Act of 1946, and the Industrial Disputes Act of 1946. So these 3 laws are being subsumed under the Code on Industrial Relations. Now what are the major provisions of this Code on Industrial Relations? The first important provision is that it has expanded the definition of worker. It has expanded the definition of worker to include the persons who are employed in skilled, unskilled, manual, technical, operational or clerical capacity. So the persons who are employed in skilled work, unskilled work, manual, technical, operational or clerical capacity, they are defined as workers. Also the persons who are employed in supervisory capacity and they are earning more than 18,000 rupees per month, they are also classified as workers. Now workers who are in administrative capacity or managerial capacity or in supervisory capacity, but earning more than 18,000 rupees per month, they will not be included in the definition of worker. Now, this has been prescribed in the code, but what is administrative capacity? What is managerial capacity? This has not been defined. This has not been specified. So this is a loophole in the Code on Industrial Relations. Now the Code on Industrial Relations, it talks about fixed term employment. What is fixed term employment? Fixed term employment, it gives the employers the flexibility to engage workers on the basis of a written contract. Now, gives employers flexibility to engage workers based on a written contract. Now, these fixed term employees, they will be getting the same benefits as permanent employees. These employees, they are hired for a fixed period. They are hired for a fixed period and they are getting the same benefits as permanent employees. And they are also on the payroll of the establishment. Also, we have seen, also in case of contract workers, the contract is executed through a middleman. That is the contractor. That is, the establishment will take the services of a contractor and that contractor will provide the contract workers. So there is a middleman involved in the case of contract work. But in case of fixed term employment, there is no role of middleman. So the contract will be negotiated directly between the employer and the employee. That is the employer and the worker. No role of middleman, and they will be on the payroll of the establishment. In case of contract workers, they are not on the payroll of the establishment. Also, what is the difference between the fixed term employees and the permanent employees? The major difference is that in case of retrenchment of permanent employees, so if you are trying to retrench the permanent employees, what is retrenchment? Retrenchment means that you are taking them out of work, you are laying them off. So if you are laying off the permanent employees, but if you are laying off without disciplinary action, that will be treated as retrenchment. So in case you are dismissing the employee based on some disciplinary action because the employee has misbehaved or there is some disciplinary proceeding, then that is not retrenchment. If you are laying off the worker, if you are taking the worker out of work, but not based on any disciplinary action, but because of other reasons, then that is retrenchment. So in case of retrenchment of permanent employees, a prior notice is required to be given. But in case of retrenchment of the fixed term employees, there is no prior notice required for retrenchment. So after the fixed term is over, without giving any notice, the employer can take them out of employment. Also, in case of a permanent employee, the nature of work is specified. In case of contract workers also, the nature of work is specified, but in case of the fixed term employees, the nature of work not specified. Now see, in case of contract workers, it has been specified in the Contract Workers Regulation Act 1970 that contract workers, they will be hired for work which is not of a perennial nature. So contract workers, they will be hired for work which is not of a perennial nature. Then they will not be hired for work that is necessary for the business. Also, they will not be hired for the same work that is carried out by the regular workers. This has been specified in the Contract Workers Act. Also, in the 2020 bill on the labor codes, 2020 bill that was passed by the parliament, the 2020 bill, it says that contract workers, they will not be hired for any core activity. So contract workers, they will not be hired for any core activity. They can be hired only for non-core activities. They will not be hired for any core activity except for activities which are ordinarily done by the contract worker. So if any establishment, some activity is ordinarily done by a contract worker, then contract worker can be hired for that activity. And in case the activity is such that the activity is such that it does not involve the full-time workers for a major portion of the day, then the contract workers can be hired for that activity. Also, if in case there is an increase in work suddenly, then also the contract worker can be hired for that activity. And the contract worker, they cannot be hired for core activities. Now, what are core activities? For understanding core activities, we need to see that the government has classified 11 non-core activities. Now, the government has classified 11 activities which are non-core in nature. These 11 activities, they include activities like sanitation, like security services, that is the security guards. Also, any activity of intermittent nature, even if that constitutes core activity of the establishment. So any activity of intermittent nature, so activity is not permanent, it is of intermittent nature, and that activity may be a core activity of the business, but it is of intermittent nature, so contract worker can be hired for that activity. So this was about the activities in which the contract workers can be hired. So they can be hired for non-core activities. They can be hired for activities which are ordinarily done by contract workers, activities in which full-time workers are not required for major portion of the day. And if there is a sudden increase in work of the establishment, contract workers can be hired. Now, in case of contract workers, it is clearly specified for what activities they can be hired. But in case of fixed-term employees, then the kind of activities for which they can be hired is not specified. Now, there is a drawback of hiring these fixed-term employees, which is detrimental to these fixed-term employees. Now, the drawback is that the contract that after their tenure is over, the employer can take them out of the employment. Now, the employer has got a greater bargaining power. Now, the employer is also empowered to renew their contracts. So, the fixed-term employees, they may hesitate to bring out their grievances because they may fear that if they raise their voice, if they bring out their grievances, the employer will not renew their contract. So there is greater bargaining power with the employer. So this leads to exploitation of the worker, leads to violation of the workers' rights. As we have seen that in the Telangana factory, the Sigachi industries, the number of permanent employees was negligible, and most of the employees were either contract workers or fixed term employees. So these people, they have got less bargaining power. They are hesitant to bring out their grievances because they fear that the employer may take them out of employment. Or in case of fixed term employees, they fear that the employer may not renew their contracts. Now the next important provision of the Code on Industrial Relations is that it has increased the threshold to 300 workers in two cases. So if the employer wants to if the employer wants to hire and fire the workers, then the threshold has been increased to 300. So earlier the threshold was 100. So in case any industry had more than 100 workers, then in order to hire and fire workers, it had to take government permission. Now this threshold has been increased to 300. So in case any industry has less than 300 workers, it does not need government permission to hire and fire workers. So this is favoring the employer, and this is in a way eroding the worker rights. So this is dilution of the labor laws. Also, in case of requirement of standing orders, the threshold has been from 100 to 300 workers. Now, what are standing orders? Standing orders means that the industrial establishment, it can issue orders. Now, the industrial establishment is required to issue orders regarding the classification of workers. What are the kinds of workers that are working there, like the fixed term employees or the permanent employees or contract workers? So there has to be a proper record. And second, standing orders regarding manner of informing the workers about working hours. What will be the working hours? Leaves, pay days, wage rates. So the manner of informing workers regarding the working hours, leaves, pay days, and wage rates. This also constitutes part of standing order which the industrial establishment has to undertake. Then the establishment has to pass standing orders regarding the termination of employment. Like what are the conditions on termination of employment? How can the employment be terminated? Also, the establishment has to provide information regarding the grievance redressal mechanisms. Now, the threshold for the standing orders earlier was 100 employees, now it is 300 employees. So, earlier, case an industrial establishment had less than 100 workers, it did not need to provide the standing orders, that is, the information regarding classification of workers, the manner of informing workers about working hours, wage rates, etc., manner of informing the workers about the termination of employment, how employment can be terminated, and about grievance redressal mechanisms. So this information did not need to be provided if the establishment was having less than 100 workers. And if the establishment had more than 100 workers, this information had to be provided. Now this threshold has been increased to 300. Now this information, now if an industrial establishment is having less than 300 workers, then there is exemption from the requirement of standing orders. So this again is favoring the employer and it is diluting the workers' rights. Because in case any industrial establishment has less than 300 workers, it does not need to pass the standing orders regarding classification of workers, regarding the manner of informing workers about working hours, pay days, holidays, wage rates, information to the workers regarding termination of employment and grievance redressal. So this is in a way a dilution of workers' rights. Also, the Code on Industrial Relations, it provides for a reskilling fund for the retrenched workers. In case the worker has been retrenched from the employment, then the reskilling of the worker will be done. And where will the fund come from? The reskilling fund will have contribution from the employer. So the employer will contribute 15 days of the wages that are last drawn by the worker to this reskilling fund. So employer will contribute this amount to the reskilling fund, and this fund will be used for reskilling the retrenched worker. The next important provision of the Code on Industrial Relation is about migrant workers. Now, there is a helpline for grievance redressal of migrant workers. Now, what are migrant workers? Migrant workers include the workers that are migrating from one state to another for employment. Now, earlier there was a 2019 bill regarding the labor codes, and the 2019 bill says that the migrant worker will be a worker whom the employer sends from one state to another for work, or whom the contractor sends from one state to another for the purpose of work. That was a migrant worker according to the 2019 bill definition. Now this definition has been further expanded to include the workers who of their own volition are migrating from one state to another for the purpose of work. So the definition of migrant worker has been expanded. Now the Code on Industrial Relations, a helpline for grievance redressal of the migrant workers has been provided. Also, a national database for migrant workers has been provided. There is a provision of 1 day leave for every 20 days that the migrant worker has worked. So when the work is done for 180 days instead of 240 days, then there is a provision of 1 day leave for every 20 days worked. Then provision regarding women. So now women are allowed to work in night shifts, that is from 7 p.m. 6 a.m. Also they are allowed to work subject to the consent of the women, and also the employer needs to provide for their safety. So the employer needs to ensure that there is adequate safeguards and provisions for safety of the women. Now, in case of workplace accident, in case there is death or injury of worker due to any workplace accident, then compensation will be provided to the worker. This compensation will include 50% share of the penalty that is imposed on the employer. So the employer penalty is imposed on the employer. 50% share of that penalty will be given to the worker in addition to the employee's compensation. So government will be providing employees compensation also, and in addition to that 50% of the penalty imposed on the employer that will be given to the worker. Then the code also talks about a social security fund. So social security fund will be constituted for the unorganized workers, for the gig workers, and for the platform workers. Now, unorganized workers, they are the workers that are not provided any formal social security benefits like gratuity or insurance. and they are not covered by the Industrial Disputes Act of 1947. Now, gig workers are workers that are outside the traditional employer-employee relationship, and platform workers, they are the workers who are accessing their employment by means of an online platform. Now, a social security fund has been provided for these unorganized gig and platform workers. Where will the contributions to the social security fund come from? The contributions to the social security fund will be realized from the will come from the amounts realized from compounding of offences. So a number of offences have been prescribed under these codes. For example, offences of imprisonment, case of 1 year imprisonment and fine. There is provision of compounding of offences, and the amount paid will be 75% of the penalty imposed in case of imprisonment and 50% of the penalty in case of fine. Also, in the Code on Occupational Safety, there is there is an amount of 75% in case of non-maintenance of register. So, in case the employer is not maintaining the register, then 50% amount will be paid, and in 50% of the fee imposed, that will be paid for compounding of the offence. And in case the employer is not maintaining records the register, then 75% of the fine will be paid for compounding of offences. So these fines which are imposed for compounding of offences, the amount realized from these fines, it will be contributed to the social security fund, which will be used for welfare of the workers, welfare of workers of the unorganized sector, and as well as the gig and platform workers. Now we talk about industrial disputes. So this industrial relation code also talks about what is an industrial dispute. Any dispute which includes discharge, retrenchment, or termination of services of an individual worker, that will be regarded as an industrial dispute. And the worker may apply to an industrial tribunal for adjudication of dispute. So the code provides for industrial tribunal as well as a national industrial tribunal for adjudication of dispute. Now in the code there is a provision that initially there will be a conciliation officer who will try to resolve the dispute, and in case the worker, in case any party is not satisfied with the decision of the conciliation officer, then the worker may apply to the tribunal 45 days after application for conciliation of the dispute was made. So these are the provisions for dispute resolution. Now, a tribunal has been provided for resolution of the dispute. In case the employer or the employee is dissatisfied with the decision of the inspector, of the labor inspector, they can appeal to the tribunal. But whatever award is given by the tribunal, that award can be rejected or modified by the government. Now, this is a controversial provision, because what if the government itself is a party to the dispute? The inspector belongs to the factories department of the government, and the government is itself a party to the dispute. Now, this provision allows the government to sit in appeal over the decision of the industrial tribunal. So this amounts to a conflict of interest. And it also violates the principle of separation of powers. So this is a controversial provision in the Industrial Relations Bill, which allows the government to reject or modify the judgment of the tribunal. However, the government has to place this before the legislature also. It has to place its reasons for rejection modification for the legislature, but then, as we already discussed, when government is sitting its appeal over a dispute to which it itself is a party, then it amounts to conflict of interest. Now we come to the third code, which is the Code on Occupational Safety, Health and Working Conditions. As we just saw that in the Sigachi Industries chemical disaster, the safety norms were not followed. The provisions for safety, they were not followed. Now this Code on Occupational Safety, Health and Working Condition subsume 13 different laws, and these 13 different laws include a large number of laws like the Factories Act of 1948, the Building and Construction Workers Act of 1996, the the Plantation Labor Act of 1951, the Contract Labor Regulation Act of 1970, the Interstate Migrant Workmen Regulation of Employment Act of 1979, then two acts concerning the working conditions of the journalist, Sales Promotion Employees Act of 1976, the Bidi and Cigar Workers Act, etc. So there are a total of 13 laws that are being subsumed by this. Also, this Cinema Workers Act is also subsumed in this. Now, what are the main provisions of this Occupational Safety, Health and Working Conditions Code? One very important provision is that it has expanded the definition of factory. It has expanded the definition of factory. Now, earlier, a factory included an establishment which was engaging in manufacturing activity. Factory included an establishment which was engaging in manufacturing activity and was employing 10 workers in case the establishment was operating with power, and employing 20 workers if the establishment was operating without power. So this was included in the definition of factory earlier. Now this definition has been changed, it has been expanded, and now a factory includes an establishment which is engaged in the manufacturing activity and it is employing 20 workers in case of an establishment without power, 20 workers in case of an establishment with power, and 40 workers in case of an establishment without power. So the threshold has been increased, the definition has been expanded. Now, second important provision is that the employers have to ensure that the workplace is free of hazards which cause injury or occupational diseases. Also, the employers are required to provide free annual health examination and tests for the workers. Next important provision is with respect to the interstate migrant workers. Now, interstate migrant workers, the 2019 bill, it the definition of interstate migrant workers to include the workers who are sent by the employers or the contractors in the state for the purpose of any particular work. 2019 bill included the definition of interstate migrant workers to include the workers who are sent by the employer. So the interstate migrant workers, they included the workers that were recruited by an employer contractors for working in another state, and the workers which were drawing wages within the maximum amount that was notified by the central government. So there were two provisions. One is that they were being sent by the employer contractor for working in another state, and the second provision was that they were drawing wages within the maximum limit that was specified by the central, that was notified by the central government. Now the 2020 bill, the 2020 bill which was specifying the provisions of the labor codes. The 2020 bill brought in one additional provision, and the additional provision was that any worker who moves on his own to other state, any worker who is moving on his own to another state and obtains employment in another state, that person will also be considered an interstate migrant worker. Someone who has come on his own from one state and received employment in another state and is earning up to 18,000 rupees per month, that person will also be included under interstate migrant workers. And there will be portability of benefits like PD and other construction workers cess for the interstate migrant workers. Also, the employer will be required to pay journey allowance to the interstate migrant worker. Now, for another provision, important provision is about appointment letter. So, the workers who are being appointed for the first time, they will receive an appointment letter, and this is a progressive step towards formalization of employment. Then another important provision is that the manpower limit on hazardous working conditions has been removed. Earlier, in the 2019 bill, there was a provision that only establishments having 10 or more workers, they will be considered for classification under hazardous employment. But now this requirement of 10 or more workers has been done away with. Now, regardless of the number of workers, an enterprise can be classified as an enterprise with hazardous working conditions based on the nature of work that is being carried out in the enterprise. Next important provision is that it makes the application of the code obligatory for contractors who are recruiting 50 or more workers. Contractor is recruiting 50 or more than 50 workers, then the application of the occupational safety, health and working conditions code will be obligatory. Earlier in the 2019 bill, the threshold was 20 or more workers. So in case a contractor was recruiting 20 or more workers, application of the code was obligatory. Now this threshold has been for more workers. Then about the daily work hour limit. So there is a daily work hour limit of 8 hours. Minimum 8 hours, and so maximum 8 hours of work can be done. This is the daily work hour limit. Then about the employee, in case the workers are working overtime, then twice the standard wages have to be paid. Next, about women work. So the women, they are allowed to work in night shift subject to their consent and ensuring of safety by the employer. Now the cinema workers, they have been designated as audio-visual workers. So the sign workers have been, and cine workers, they have been designated as audio-visual workers. Earlier, only the artists, that is the actors, were working in the films, only they were designated as audio-visual workers. Now the cinema workers, other cinema workers like the technicians, etc., they have also been designated as audio-visual workers. What is the benefit of this? The benefit is that now these other workers like the technicians, etc., they will also be covered under the occupational safety code. Now we come to the next important code, that is the code on social security. Now this code on social security is subsuming a total of 9 laws. And what are these 9 laws? Some of these laws include the Employee Provident Fund and Miscellaneous Provisions Act of 1952. Another includes the Employee State Insurance Act of 1948. Then the Employee Compensation Act of 1923. In the Employment Exchanges Notification of Compulsory Notification of Vacancies Act of 1959, the Maternity Benefit Act of 1961, the Building and Construction Workers Cess Act of 1996, and the Unorganized Workers Social Security Act of 2008. These are some of the important acts, important laws that are being subsumed in the Code on Social Security. Now, what are the major provisions of this code? Major provisions include, one is that the definition of employee has been expanded to include interstate migrant workers, construction workers, film industry workers, platform workers, and gig workers. Also, it empowers the state to notify various social security schemes like Employee Provident Fund, UPS, Employee State Insurance, for the benefit of workers in all sectors. Then, facility of is ESIC, that is the Employee State Insurance Corporation. It will be provided in all 740 districts. At present, it is 566 districts. Now, the number of districts will be increased. Number of districts will be increased to 740. Then, the Code on Social Security empowers the center to frame any other schemes for the self-employed, unorganized workers, gig workers, and platform workers. Also, the EPFO coverage, it is applicable to establishments having at least 20 workers. So before the code, it was only to those establishments which were listed in the schedule of the Act, and now it is applicable to all establishments that are having 20 or more workers. Now, firms with more than 20 workers, they have to mandatorily report their vacancies online. And now, another important provision is that there will be constitution of a National Social Security Board. A National Social Security Board will be constituted, and this National Security Board will advise the government regarding the schemes that are to be implemented for the unorganized sector workers, as well as for the gig unorganized workers, unorganized sector workers, the gig workers, as well as the platform workers. Then there will be constitution of a social security fund. So a social security fund will be constituted for welfare of the unorganized sector workers, the gig workers, and platform workers. And this social security fund will be financed by the contributions that are obtained from compounding of offences. Then the gratuity for fixed term employees. In case of gratuity for fixed term employees, there is no condition of minimum service period. So in case of gratuity, there is a condition that minimum 5 years of service is required. But in case of fixed term employees, there is no condition of minimum service period. They will be provided gratuity on a pro rata basis, that is on a proportionate basis based on the amount that they have served. Then the gratuity period for the working journalist has been reduced from 5 to 3. Gratuity period has been reduced for the working journalist. Then there is a provision for national database for unorganized sector workers. So there will be a national database for the unorganized sector workers, and the registration will be on the basis of self-certification and Aadhaar card. So on the basis of self-certification, there will be registration on this database. Then what are the common issues across the 3 labor bills? So the common issues across these bills are, first is the issue of appropriate government. Appropriate government means the government which is empowered to frame regulations to ensure compliance, etc. Now, the courts, they say that central government will be appropriate government even if the central government is having less than 50% ownership in the establishment, in the public sector enterprise. So this is a controversial provision. So when the government is having less than 50% ownership in the public sector enterprise, then how can it be considered the appropriate government? But the courts, they say that the central government will still be considered the appropriate government. Then another common issue is that of delegated legislation. What is delegated legislation? Delegated legislation means that the legislature will will frame the broad policy. It will leave the finer details to be filled in by the executive. It will delegate the lawmaking powers regarding finer details of the law to the executive. Now, in this case, in case of the labor bills, certain functions and powers they should not be delegated to government. Now, the labor courts they are delegating various essential aspects of the laws to the government. Now, these essential aspects of the laws include increasing the threshold for layoff, retrenchment, and closure. Now, layoff, what is layoff? Layoff means that the worker is taking the employees out and the employer is taking the employees out of service, is taking the workers out of service because of certain adverse work conditions. Suppose the business is running in losses, there are adverse conditions, or there is COVID pandemic. So that is the case of, in that case, if the employer is taking the workers out of service, that is called a layoff. Then about retrenchment, what is retrenchment? Retrenchment means that the workers are being dismissed from service, that they are being taken out from service because of reasons other than disciplinary action. So if there are reasons other than disciplinary action for which the workers are being taken out of service, that is retrenchment. So the threshold for layoff, retrenchment and closure, they have been increased from 100 to 300 workers. So earlier an establishment had more than 100 workers, it had to take permission of the government before laying off or retrenching workers, that is hiring or firing workers. Now this threshold has been increased to 300 workers. So now if an establishment is having more than 300 workers, it needs government permissions before laying off or retrenching the workers. Threshold has been increased and the executive has increased this threshold. So this is an action in favor of the employer and is adversely affecting the workers' rights. So hiring and firing of workers has become easier due to this change. And this has been done by the executive. So this is an example where the executive is deciding crucial aspects of the law. Now, if this law had been decided by the legislature, then it would be more fair because the legislative oversight is greater. If the parliament, if the legislature had decided these aspects, it would be more fair to the workers. But instead, the executive is deciding these matters on its discretion. So this is a case of delegated legislation, which should not have been there because the legislature should have been empowered to frame laws on such important matters. Then the executive is setting the threshold for applicability of various social security schemes. So for applicability of various social security schemes, like the executive is deciding the thresholds. So these thresholds are based on the size of the establishment, like 10 workers, 20 workers, or within the same establishment, it is based on the income levels, how much the workers are earning. On the basis of these factors, what social security provisions will apply to workers is decided. And this setting of threshold for applicability of social security scheme also being done by the executive. Again, an example of delegated legislation which is not the interest of workers. If the legislature had decided these thresholds, it would be more fair to the workers. Again, the executive is specifying the safety standards and working conditions to be provided by the establishment under the Occupational Safety Code. So the executive is specifying the safety standards and working conditions. Again, executive discretion. It is a case of delegated legislation which is not desired. If the legislature was deciding these things, it would be more fair to both the parties. So this kind of delegated legislation is not desired. So certain functions and powers should not be delegated to the government, like framing legislative policy to determine the principles of law. Also, any rule should remain within the scope of the delegating act. Now the government has been given discretion in exempting the establishments, the industrial establishments from application of the labor codes. So this is contrary to the interest of workers. So the government at its discretion can exempt industrial establishment from application of the codes like occupational safety codes in public interest. The government can exempt factories if in case they are in cases where it is satisfied that it qualifies for exemption because the factory is providing economic activity and it is also providing employment. These discretionary powers in the hands of government are not favorable. Such delegated legislation where the government is determining essential aspects of laws which should be ideally determined by the legislature, they are not favorable. So the standing committee had recommended that the courts they are allowing the executive to decide the entitlements, benefits and contributions under the bill, and it recommended that this provision should be changed. Then the courts are giving the power to the government to exempt establishments from application of the labor codes in public interest. This is also a controversial provision. In case any factory is providing is creating enough economic opportunity and employment, then government can even exempt it from application of labor laws, which is detrimental to the interest of workers. Provisions of fixed term employment. Now, fixed term employees, the nature of work which will be included in fixed term employment is not specified. Also, in case of fixed term employees, the employer has got more bargaining power. So the fixed term employees, they will be hesitant to raise their grievances in front of the employer because it is the employer which is going to renew their contracts. So they will fear that if they raise their genuine grievances, if they raise their voice against the employer, then they may not be their fixed term contract may not be renewed. So these provisions on fixed term employment are also not in the interest of workers. Then a very important issue is that the civil code, they are barred from hearing matters under the code. In case there are violations under the code, the civil court's jurisdiction has been barred. Now, in case suppose there is a labor inspector and the employer is aggrieved with the decision of the labor inspector, the employer can appeal to the tribunal. But the orders of the tribunal cannot be further appealed in the district courts. So the tribunal's orders, they cannot be appealed for the district courts. And this is a controversial provision. Now the only recourse to the employer is to file a writ petition before the High Court. So judicial oversight has been excluded. Then another important issue is that the government has been empowered to reject or modify the awards of the tribunal. So the government has been empowered to reject or modify the tribunal awards. Now this also amounts to a conflict of interest as we have seen earlier. So the government, suppose there is an order by the labor inspector, one of the parties is appealing against the order of the labor inspector, the tribunal. Now the tribunal award, they can be rejected or modified by the government. Now government, suppose in case of labor inspector, the inspector belongs to the factories department of the government. The government is itself a party to the dispute. Government is sitting in appeal over the judgment of the tribunal. Is sitting in appeal over a decision over a case to which it is itself a party. So this amounts to serious conflict of interest. It also violates the principle of separation of powers. Then another important issue with the labor codes is the fragmented system for delivery of social security benefits. So the system for delivery of social security benefits, it is fragmented. There is no unified structure. For example, in case of benefits for employee provident fund, employee pensions, employee deposit linked insurance scheme, the oversight is by the Central Board of Trustees. So the Central Board of Trustees is going to deliver these benefits. In case of the employee state insurance scheme, the benefit is delivered by the employee state insurance corporation. Then in case of the schemes for unorganized workers, the administration is done by the national and state welfare social security boards. And in case of administration of the welfare boards for construction workers, then that in case of construction workers, it is done by the cess-based welfare boards. So there are different administering agencies for delivery of social security benefits. So the system is fragmented. So a compact and unified system is needed. Now next important issue with these labor codes is that the strikes and lockouts, they may become difficult. If an important labor codes, that it may make it difficult for the workers to go on strikes and lockouts. How will it make it difficult? Because now there is a provision in the codes that before a strike, a notice has to be given. Notice has to be given 14 before the day of strike, and this notice is going to be valid up to a period of 60 days. Now, immediately after giving this notice, the conciliation proceedings will take effect. They will start the conciliation. Now, see, first the notice will be given 14 days prior notice before strike will be given. Then the conciliation officer will be informed within a period of 5 days. And then the conciliation proceedings, they will start immediately. They will start. Now, during and 7 days after the conciliation proceedings, the strike cannot be started. Case also 60 days after the tribunal proceeding, the strike cannot be started. Now, once the conciliation process starts, the conciliation judgment is given, and when any of the parties is not satisfied with the judgment, then they can apply to the tribunal. Application to the tribunal by either party. And now if we are applying to the tribunal, then 60 days after the tribunal proceedings, during and after the tribunal proceedings, again the strike cannot start. This way, we can see that validity of the strike was 60 days after validity of starting the strike was 60 days after giving the notice. And this 60 days period will pass in the conciliation proceedings and the tribunal proceedings. Strikes and lockouts, they may become difficult. Again, I summarize it. Why will the strikes and lockouts become difficult? Because time period of 14 days prior notice is required before calling a strike. And this notice is going to be valid up to 60 days. Then after giving notice of strike, within 5 days the conciliation officer needs to be informed. Conciliation proceedings will start. Then during conciliation proceedings and 7 days after conciliation proceedings, the strike cannot start. In case any party is dissatisfied with the judgment of the conciliation officer, then they can appeal to the tribunal. Again, during the tribunal proceedings and 60 days after the tribunal proceedings, the strike again cannot start. So this will lead to expiration of the 60-day validity period for the strike. In this way, the strike and lockout can become difficult. Now, these were the issues with the labor codes. Now, what are the improvements suggested? How can we improve upon them? Improvements are that first, the National Commission on Labour in 2002 had recommended a separate law for small scale units. Now see, at present there are thresholds. The Social Security Code, there are different thresholds of 10 or 20 workers which the social security norms or social security schemes will become applicable. Application of the social security code will become applicable only for establishments having workers above this threshold. In case of the occupational safety code also, there is a threshold for establishments having 10 or more workers. It will be applicable. Now, this excludes the workers who are working in establishments having less than 10 workers. How will these workers be covered under social security net or under the provisions of labor codes? So, excluded workers, National Commission on Labour had recommended a separate law for small-scale units having less than 20 workers. This separate law will have less stringent provisions for conditions such as payment of wages, welfare activities, social security, retrenchment and closure, and resolution of disputes. So this will have less stringent provisions. This will cover the excluded workers also. And for unorganized sector workers, for unorganized sector establishments which fall outside the purview of labor laws, the National Commission for Enterprises in Unorganized Sector, it made recommendations to address social security and minimum conditions of work for both agricultural and non-agricultural workers. So this National Commission for Enterprises in the Unorganized Sector, it made recommendations for addressing the social security needs and minimum conditions of work for agricultural workers and non-agricultural workers. So it suggested two bills, one for each sector. Then another suggestion is that at present the government has been given discretionary powers to exempt certain enterprises from the application of labor codes in public interest. Also, enterprises having less than a certain threshold of workers, they may not be covered under the labor codes. But in most countries, this practice is not followed. Most countries, they do not exempt smaller enterprises from labor regulation entirely. So they have some provisions covering the smaller enterprises also. So the ILO, it notes that in its 2005 report, it notes that only 10% of its member state had exempted the MSME from labor regulation altogether. So only 10% of the member states in the ILO, they had exempted the micro, small and medium enterprises from the labor regulation altogether. So this means that most of the member states, they did have some labor regulations for smaller enterprises as well. So most countries, they are adopting a mixed approach to labor regulation. For example, health and safety laws in the US, UK, South Africa and Philippines, they provide for universal coverage of all workers. So health and safety net for all workers is there in these countries, except domestic help in US and UK. So in US and UK, domestic help is not covered under health and safety laws, but all other workers are covered. So in India, we saw that in the Telangana disaster, the employees the employees of the factory, they were covered with accidental insurance as well as health insurance, but the workers, they were not, the workers that included the fixed term employees, etc., they were not covered by the health insurance. They had accidental insurance, but they did not have the health insurance. So this shows the lack of coverage in terms of health and safety. Now these countries like the US, UK, South Africa, etc., they do have certain obligations that are applicable only to enterprises with employees over a certain threshold of workers. For example, record keeping obligations for work-related accidents in the USA, they only apply to establishments with at least 10 employees in low-hazard industries. In South Africa, only enterprises with 10 or more workers are required to designate a health and safety representative. So most countries, they do not exempt smaller enterprises from labor regulation entirely, and India should also learn from them. We should have some labor regulation, some social security net for enterprises which are small, for enterprises which are employing less than 10 or 20 workers. Then we should restore workplace safety as a right. This is very important. We should reinstate inspection as enforcement. So merely self-certification or third-party verification, they are not sufficient. We need to reinstate proper inspections by government inspectors for enforcement of the labor laws. Also, at present, the Workers' Compensation Act, etc., they are not holding the employers responsible. They are not holding the employers criminally liable for preventable deaths. So we need to fix responsibility on the employers. Employers need to be held criminally liable for the preventive deaths, for the preventable deaths. Now these were about the suggestions in the that can be made for improvement in the labor codes. Now we come to the draft labor policy that has been brought by the government of India recently. This has not yet passed. This has not yet become law. Suggestions are invited for this policy up to October 27th, 2025. Now, what is this draft labor policy? Now, this draft labor policy aims at universal worker registration, portable social security accounts for all workers by the year 2030, aims to raise the women's labor force participation to 35%, and it offers a single window digital compliance system for the micro, small, and medium enterprises. It aims at creating green jobs and artificial intelligence enabled safety. And it proposes to create a universal social security account by integrating the present schemes like PFO, ESIC, PM Jan Arogya Yojana, E-Shram, and the State Welfare Board. So it aims at integrating the existing social security schemes. And this draft labor policy is going to be implemented in 3 phases. It will be implemented in 3 phases. What are these? The first phase will be from 2025 to 27, that is 2 year period. It will aim at building the institutional setup as well as it integrating the existing social security schemes like EPFO, ESIC, PM Jan Arogya Yojana, E-Shram, etc. into a unified system. And it is going to lay the foundation for a for a single window digital compliance mechanism for MSMEs. So institutional strengthening as well as integration of the social security scheme will be the priority during the first phase. Then the second phase, which is from 2027 to 30 for 3 year period, it will aim at universal social security expansion. So nationwide rollout of universal and portable social security accounts for all workers. So portable social security accounts. So portability will be ensured and universality, that is universal registration of workers, will be ensured. So that workers, if they are migrating from one state to another, there is portability of social security benefits. The social security benefits that had been provided in the previous state, they can be provided in the other state also. Also, in the second phase, as part of the universal social security expansion, there will be integration of skill credit systems. So in case of the skilling schemes by the central and state government, credits are provided in terms of the skill earned. Quality certification is there, credits are provided. Now these credits, suppose credits have been provided in one particular region, in one particular state, then the skill credit systems that are provided in one region, they will be integrated with other regions also. So if the worker is migrating from one place to another, then there is an integration of the skill credit system. So if the worker has earned credits in one enterprise, in one training program, then the worker shifts to another training program in another region, then there will be integration of skill credit system. The credits of the credits earned earlier, they will be added to the credits earned later. Also, establishment of district level employment facilitation cells. So these employment facilitation cells, they will help at the district level, they will help in connecting the employer and the employee. Then the phase 3 will be after 2030. After 2030, the phase 3 will start, which will aim at integrating artificial intelligence, paperless governance, integrating dashboards, and continuous monitoring. So these are the broadly the three phases that have been proposed in the draft labor policy. In case you have any suggestions that you want to give the government about the draft labor policy, you can submit your suggestions by October 27th, 2025. Now we will be doing a practice question on what we have learned. Now this practice question is, in light of the recent industrial accidents in India, examine the effectiveness of labor laws in India and suggest measures to enhance their effectiveness. So how will you write this answer? First you will talk about the recent industrial accidents in India. You can say that recent industrial accidents in India have become are a cause of concern, and they have exposed these industrial accidents have exposed the loopholes in the labor laws in India. They are proof that there is inadequate compliance with the labor laws in India, and the safety procedures are not being followed, the worker rights are being eroded. You can list some of the recent industrial accidents like the explosion at the Sigachi factory in Telangana, then the explosion at other sites. As we have just seen in the beginning of the lecture, we can list the recent industrial accidents like the explosions in the SB Organics, Sangareddy district in Telangana, then explosion in the Sigachi Industries, Telangana, Gokulesh fireworks, Shivkasi, Tamil Nadu, and Chennai's Innor Thermal Power Station disaster, and the firecracker unit in the Andhra Pradesh in the Konasima district. You can list 2 or 3 out of these. This will be your introduction. After that, in the body, you have to examine the effectiveness of labor laws in India. In this, you can start with the labor laws like the Factories Act 1948, Factories Act 1948, the provisions of which were not followed, which led to tragedies like the Bhopal gas tragedy of 1984. Then you can talk about the 4 labor codes, that is the code on industrial relations, the code on wages, the code on social security. So you can talk about these 4 labor codes, and the 4th code is the occupational safety working conditions code. Talk about how the provisions of labor laws in India are being flouted. First, you can talk briefly about all the 4 codes, like the code on industrial relations. The code on wages is prescribing the minimum wages for workers, the floor wage, etc. The code on social security is listing the social security provisions for the workers. The code on industrial relations is talking about resolution of industrial disputes. The code on occupational safety is prescribing the safety norms for the workers. As we have discussed about these codes, you can write briefly about them, and after that you can talk about how in case of industrial accidents the labor laws were not followed. Like reports are being given regarding after each accident, but these reports are not being taken seriously by the government. You can talk about the flaws in the 4 labor codes in India. What are the flaws? As we have already discussed the different flaws in the labor laws. Now these are the flaws. The central government has been given discretionary powers regarding exempting establishments from the application of labor codes in public interest. The government can exempt factories from application of the labor codes. They are generating economic activity and providing employment. Also, The government is empowered to increase the threshold for hiring and firing of workers, increase the threshold for applicability of social security scheme, for setting the threshold for applicability of social security scheme, prescribing safety conditions, safety standards for workers. These are these powers are given to executive, and if these powers had been given to the legislature, it would be a more fair procedure. And you can talk about the fact that civil courts have been barred from hearing matters under the labor codes. So this is also a flaw in the labor codes. Also, the government can reject or modify the tribunal awards, leading to conflict of interest. You can talk about the fragmented system for delivery of social security benefits. So these are the flaws in the labor laws that you can talk about. Now, the next part of the question talks about measures to enhance effectiveness of the labor laws in India. Now, as part of the measures to enhance the effectiveness of labor laws in India, you can talk about the fact that at present establishments with less than 10 workers, they are not being covered adequately by the labor codes. So we need to have provision for establishments with less than 10 workers also. We need to have a separate law for the small scale units with less stringent provisions for conditions like wage payment, welfare, social security, retrenchment, etc. Then you can talk about the example of different countries like US, UK that do not exempt smaller enterprises from labor regulation entirely. Then you can say that we need to restore the workplace safety as a right, and we need to reinstate inspections as enforcement. Self-certification and third-party verification alone are not sufficient, and employers need to be criminally liable for preventable deaths. Then finally, as part of the conclusion, you can say that the government, we need to make improvements in the labor laws, need to improve upon the loopholes, and the governments, they need to take course correction after industrial accidents. The reports on industrial accidents, they need to be taken seriously, and we need to move away from the dilution of labor regulations in the name of ease of doing business. And you can also say that the draft labor policy of the government, which has recently been brought, the positive step in the direction of providing portable social security accounts, universal worker registration, increasing women participation, etc. So this is how you can write this answer. So again, I'll summarize how you can write this answer. In the introduction, you will talk about how the recent industrial accidents in India are a cause of concern, and these point to the lack of proper enforcement of labor laws in India. You can give examples of certain recent industrial accidents. Then in the body, we will talk about the different labor laws in India, like the Factories Act of 1948, how the improper following of the provisions of Factories Act, and it led to the Bhopal gas tragedy. Then you can talk about the 4 labor codes in India. You can point out You can talk briefly about the 4 labor codes and then point out the flaws in these labor codes, about how there is a fragmented social security system, how the executive has been given discretionary powers for exempting establishments from application of the code in the name of public interest, and how the jurisdiction of civil courts have been barred under the codes, and also how there is a conflict of interest because the courts, they allow the government to sit appeal over the decisions of the tribunals in cases to which the government itself is a party. So the government can modify or reject the tribunal awards. This is also a flaw in the present labor codes. And you can talk about how the lack of compliance with the labor laws, how the diluting of labor laws, the name of ease of doing business, has led to these industrial accidents. Also, that self-certification and third-party verification, they alone are not sufficient. We need to bring proper enforcement mechanisms by means of inspectors from the factories department. There needs to be regular inspections. Then in the conclusion, you can say that there is a urgent need to improve upon the labor regulation in India, and the draft labor policy of the government of India, that is a positive step in this direction. Then talk briefly about how the draft labor policy aims at universal worker registration, portable social security accounts for all workers, increasing women labor participation, etc. And in this way, we can conclude the answer by saying that we need to undertake proper course correction after each industrial accident in order to prevent such, and also we need to improve up, we need to refrain from diluting the labor regulations in order to prevent such industrial accidents in the future. So with this, we come to the end of this video, and the workers' rights, they need to be taken care of, because the hands that build the nation, they deserve the highest respect. So we need to take care of the interests of our labor class, and we conclude the video. Thank you.